Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're talking about an unusual freedom of expression case. Is your garden a form of artistic or political expression? I think that it is, and courts in Ontario sometimes agree. But there is still tension between gardeners and municipalities, especially when homeowners have what are called naturalized gardens. Naturalized gardens mimic a naturally occurring habitat. Instead of rows of hydrangeas and neatly trimmed grass, naturalized gardens have native plants and look like a forest, a meadow, or a wetland. King Charles has actually famously championed wildflower meadows at his home at Highgrove. These gardens are not just an aesthetic expression, they can also express environmental and ecological beliefs, as well as an anti-colonial sentiment that emphasizes the value of our native plants over imported cultivars. But one man's wildflower meadow is another man's unkept lawn, and some municipalities have actually cracked down on naturalized gardens, with bylaw forcibly mowing down these gardens and then later billing the homeowner. Is this a violation of homeowners' charter protected rights? Today, we're joined by Wolf Ruck, a Mississauga-based homeowner and gardener who's fighting the city over his naturalized garden. Wolf, thank you so much for joining me today. Let's start with an explanation of these naturalized gardens. Can you explain to me why you view this as an expressive act, and maybe what you're trying to express with your garden?
Yes, thank you very much, Christine, for your interest. Um, the yard, I call it, I'm a yardner, not a gardener, in the sense that I'm maintaining a yard in a sort of naturalized state. That is a rewilding process that's been going on since about 2021 and a bit earlier. And it is a form of expression in terms of what I consider to be valuable, what I consider to be a contribution towards the idea of biodiversity and the idea of minimizing our impact with respect to climate change. It's something that I'm able to do personally. And in view of the kind of news that we are continually bombarded with for several years now, with respect to drought, fire, flood, and fires, climate change, and so on and so forth, it is a statement that I'm making, and it sort of reinforces my lifelong interest in
Mm-hmm.
nature, respect for nature, uh, and appreciation for the amazing mysteries that nature offers us every
Now,
day.
we're going to put up some pictures of your garden, but maybe you can describe it to us as well. Describe what some of the plants are, describe the animals that, make home in your yard. What can you tell us about that?
All right. Um, Essentially, my yard is a series of islands that are surrounded by regularly mowed pathways. And these islands contain, for the most part, plants such as milkweed and Canada goldenrod. Those are the primary plants that exist in this naturalized area. Another plant that is there is, for example, the what's called purple moorgrass, or a type of moorgrass, which is actually an ornamental. And the whole idea is that essentially these areas I'm allowing to rewild naturally. I'm not in there consciously planting certain flowers and so on and so forth. I have in the past number of years collected seeds from parks and riverbanks and ravines that are close by, and tried to transplant some of these seeds onto my property in those garden plots, if you will.
Yeah,
And these gardens,
and those plants that you mentioned, goldenrod and milkweed, those are some of the most important for butterfly habitats as well. And there's all kinds of animals like chipmunks and things that also make home in your garden. We've got to go to commercial break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing gardening as a form of expression and a dispute between a gardener of a naturalized garden, Wolf Ruck, and the City of Mississauga. Now, Wolf, bylaw enforcement from the City of Mississauga came to your house, and you think it's because someone made a complaint, someone from your neighborhood made a complaint about your yard. Can you explain what happened?
yes, indeed. I was essentially minding my own business on my property when a bylaw officer came wandering up the driveway and essentially told me that there's been a bylaw complaint or there's been a neighbor complaint about the tall grass and weeds, and you need to cut everything. And that was quite a shock to me. Uh, the uh, the idea of my garden being a wildlife friendly and pollinator friendly area seemed to me to be, a justifiable attempt again to address certain aesthetic and environmental and ecological concerns on my part, and for the bylaw officer essentially to say I have to cut everything, that really set me back. Um, the long and short of it is that the bylaw officer actually informed me that it's very unusual to have this kind of action, if you will, bylaw enforcement, notice of contravention being issued in a residential area. Usually it is in, industrial areas where sites have been abandoned and are derelict and so on and so forth. And this certainly is not the case in my property. So I was a little bit taken aback about a bylaw complaint, which seems to trigger this kind of notice of contravention and bylaw enforcement on the part of the city.
Yeah, and it certainly, I mean, based on the way you're describing it, it seems like the enforcement action was as a result of aesthetic viewpoints. And I think aesthetic perspectives differ. I mean, you may not look at someone's rows of either their English rose garden and say, that's not for me. And someone may look at your garden and say, that's not for me. And that's okay. We're supposed to be able to celebrate these differences. Now, I know that there are tall grass and noxious weed bylaws in Mississauga, as there are in many municipalities. And I don't think that what is happening here is that you've planted dangerous plants like poison ivy that could hurt someone who wanders onto your property, or something invasive like garlic mustard, or something else dangerous like giant hogweed. There's a number of plants that are noxious and dangerous. I don't, and there's also issues with sight lines. So, if your property's at an intersection, let's say, and cars that are coming can't see through. But I don't think that's what's happening here. So what exactly is going on? I don't think you take issue with a prohibition on growing poison ivy.
Well, that's absolutely correct. And that's one of the maddening things about how this bylaw is being administered and enforced, because in fact, the way the bylaw is presented, there's actually no objectively discernible evidence with respect to what exactly is being harmful or is being, a fire hazard or is being a source of rodent infestation and or is causing allergies. There's been absolutely no evidence provided to me what exactly the transgression is with respect to my property or the plants, the
And
vegetation
and
growing
and
on
if
my property.
if they have an issue with goldenrod or milkweed, why is cities across Ontario are planting those plants in their own municipal gardens as butterfly habitats? Isn't there some hypocrisy there in them saying, we're going to plant this in city gardens, but require you to cut yours down?
Well, this is the curious thing as well, which is inexplicable to me. It's definitely a self-contradiction because on the one hand, as you say, the city of Mississauga is very, I would say, progressive in terms of its parks, et
Hmm.
cetera, creating wildlife and pollinator-friendly habitat and naturalizing areas. But with respect to private properties, the interesting thing is that the bylaw literally states
Hmm.
council deems tall grass and weeds to be a public
Hmm.
nuisance.
Welcome back to Canadian Justice, where we're discussing gardening as a form of expression and Wolf Ruck's dispute with the city of Mississauga, which wants to mow down his naturalized garden. Now, Wolf, the city of Mississauga brought this enforcement action. They had ordered you, I guess, to cut down your entire garden that you'd spent years building as a plant and wildlife habitat. And you actually took the city to court over their plans to mow your garden. And there has been a decision from the Superior Court. It found that your garden is expression, but ultimately you lost that case because the court found that based on Section 1 of the Charter, reasonable limits, that it was a reasonable limit. What do you think was wrong with the decision?
Well, I think the process, the way the decision was arrived at, in my view, is substantially flawed, both in terms of errors in law, errors in procedure, errors in fact, et cetera, et cetera. For example, one of the things that the Superior Court judge did was he essentially, literally, word for word, repeated a statement made by the city lawyer, which is that I am challenging the constitutionality of the bylaw. And in fact, if you read my application, my notice of application, and so on and so forth, which is part of the public record, this is absolutely a misrepresentation of my case. My case basically revolves around the city's violation of administrative law, the Ontario Weed Control Act, and the Charter of Rights and Freedoms. And it specifically says that. And it also says that in my reply factum to the city's initial factum regarding this issue. And my surprise and quite frankly disappointment in the Superior Court's judgment is that there is scant, if any, reference or consideration made to the arguments in my factum and in my reply factum. And I find that very problematic in terms of, the I would say the execution of justice. You know, justice is supposed to be
Mhm.
blind and equanimous and listening to both sides. In this
So,
particular case, it was just one side that was
so the
considered.
issue you had was less about this bylaw, which lists specific weeds that you can't grow, and which, by the way, you don't really have on your property. It was less an issue of the constitutionality of that bylaw and more how the city was applying the law and how they were operationalizing it. That was the problem. Is that right?
That's correct. There are certain procedures in administrative law that need to be followed by anybody who is in a position of authority to make decisions that affect you as a citizen. And one of these things is that, for example, there has to be clarity with respect to what exactly is the issue. And when a bylaw says, well, tall grass and weeds, uh, number one, which weeds? Number two, which grass? There are 1,200 different types of grasses. There are ornamental grasses, there are meadow grasses, native grasses, et cetera, et cetera. Which grass are you expecting me to cut? The problem is that in all of my interaction with the city authorities, and I'm talking about from the mayor on down to the local bylaw officer, is that all of my concerns, all of my emails, et cetera, have absolutely not been responded to in any substantive
Mhm.
way.
Now,
In other,
Wolf, we've got about a minute left, but I know that you sought an injunction to try to stop the city from enforcing this act and mowing down your grass. We've got less than a minute. What happened with the injunction?
well, the injunction was actually a mirror image of the Superior Court judge's process. In other words, only the one side, which is the city's lawyer side, was considered and was quoted. Uh, Scant, if any attention was paid to any of the arguments that I made.
Yeah, that's unfortunate.
And the evidence
And
that
one of
I
the things they
provided.
said is if your garden is cut down, it can grow back. I mean, isn't I suppose it's true, but that doesn't mean it's not harmful to destroy the habitat that you've spent years cultivating and trying to grow and creating in this naturalized environment. It kind of is missing the whole point. We've got to go to break now, but we'll be right back. Welcome back to Canadian Justice, where we're discussing gardening as a form of artistic and political expression. We're chatting with Wolf Ruck, who's a Mississauga gardener and homeowner who is in a dispute with the City of Mississauga, who wants to mow down his naturalized garden. Now, Wolf, you were unsuccessful at the lower court and you were unsuccessful in getting that injunction. What happens next? Are you planning to appeal? Are you worried that bylaw enforcement could just show up and cut everything down one day?
Well, that's a possibility, and that is certainly a cloud hanging over my head because that has happened in the last 2 years. With respect to the appeal, my request to basically put a stay on the order of enforcing the bylaw is part of my appeal, and the appeal process is, it has been filed. My application to appeal has been filed. And it's just a matter now of hopefully uh, being able to, in a forum, and I would say an unbiased forum, to present my case in detail, in more detail than was presented in the previous two cases in front of a judge. Uh, I had relied, perhaps this is a strategic mistake, but I had relied substantially on all of my written material. And I have a feeling that it was just essentially ignored in the two previous incidents or interactions with the courts. So the appeal process is the next step. And if the appeal process were again to be uh, against or be adjudicated against my request, I'm prepared to go to the Supreme Court if necessary. It's to me, it's a very, very important part of a huge movement that is literally growing day by day. There are thousands of people that are part of this rewilding, urban rewilding movement. In the United States, for example, certain state governments and municipalities are actually paying lawn owners or property owners that have the traditional lawns to rewild them because they are aware of what's at stake. And we're talking about the future essentially of the planet.
Yeah, I mean, think about all of the times that there are orders that we receive in different parts of Canada to stop watering our lawn. Well, if we had naturalized lawns, we wouldn't be faced with this same type of problem. Let's talk about that movement a little bit. We've got a minute and a half left. What do you think people need to understand about naturalized gardens? Does there need to be a cultural shift to understand the aesthetic and maybe political meaning behind that? And how do we start that shift?
Well, I think the shift has already taken place, Christine. It is a huge movement. It is growing day by day. There are people who've been on the barricades, if you will, on this issue for decades. I'm talking about people like Lorraine Johnson, uh, uh, Joyce Hostin, Nita Marie Lister. These are all people, and of course, a renowned lawyer, David Donnelly, who've been on literally the barricade, certainly in Ontario, for upgrading and modernizing these bylaws. These bylaws are on the books, and they were probably established in the 50s and 60s, and a lot has changed since that time, as we all know. And this is an unstoppable movement, I would say, and it's very worthwhile for everybody to inform themselves, to realize that this is actually for the greater public good
Hmm.
in terms of everything from fossil fuel burning to uh, countering the
Hmm.
decline in biodiversity and the decline
Right.
or the global warming situation that we're faced with.
That's all the time we have, Wolf. Thank you so much for coming on to tell us your story. We've heard today about gardening as a form of expression and disputes that have been taking place across Canada as an emerging trend of naturalized gardens is butting up against conventional aesthetics and overly vigilant bylaw enforcement. What do you think of the trend of naturalized gardens? Is it expression worthy of protection or a neighborhood hazard worthy of the state entering private property to destroy? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.